Good morning, everyone. I am Heather Kelly. I am with the Rockford SBDC. And welcome to Human Resources Compliance for Small Businesses. In case you're not familiar with the SBDC, we provide no-cost guidance to existing and startup businesses in the areas of accounting, business planning, marketing. We can help in many different areas. And because you're a taxpayer, again, our services are at no cost, and we would love to assist any of your businesses. For more information, go to rockfordsbdc.org. And a couple of reminders: next week, I will be the guest speaker presenting Do You Know Your Target Market? And going in depth into market analysis for those businesses that need assistance determining their target markets. And so with that, I will introduce our guest speaker for today, Andres Mendez. Some of you may recognize him from last week. He was also our presenter. He is from the Illinois Department of Labor, Employee Benefits Security Administration. And so I will turn it over to Andres to present.
Thanks, Heather. Again, like she mentioned, my name is Andres Mendez. I'm with the U.S. Department of Labor, Employee Benefits Security Administration. So today we'll be talking about, I guess, if you want to put it anyway, general human resource compliance. Obviously, going forward, we could probably talk about these subjects in much more detail. If the need arises, if someone's particularly interested in a certain topic. With that, I will start my PowerPoint. So just a moment while I share my screen. Can everyone see this, first of all, before we continue?
Yes. Okay.
All right. So we're going to be going over ERISA Title I, Part 7. It's really, for most of you, that's kind of meaningless. The title of the presentation here is the only problem is that, of course, I can always take PowerPoint slides out from these presentations, but I can't edit them. Otherwise, I would have chosen a much better title for you guys. Basically, today what we'll be talking about is a couple of different employee benefits laws that arise whenever you're dealing with HR matters. In particular, we're focusing on health a little bit as we did last week, and so some of the basic laws that you'll encounter in human resources. And again, I'm speaking from the federal side of things, although in a moment I'll obviously go into some of the laws that exist in the state of Illinois, just so you're familiar with them. But in terms of federal laws, the Affordable Care Act, the ACA, a lot of you probably remember this from the early 2010s, often referred to as Obamacare. Basically, they're a set of healthcare market reforms. And actually, as a consequence of this law, there was also a federal exchange, if you will, of health insurance plans that was created. Healthcare.gov, you see all the commercials during the open enrollment period for that. And of course, as I mentioned last week, the healthcare.gov website actually provides resources for small business owners who want to create a plan that specifically caters to the needs of a small business, right? So, clearly not the same as like a large business, usually much more simplified requirements. But anyways, I digress. Mental health and substance use disorder parity. We kind of touched on this a little bit last week, but essentially, there are a series of laws that have been passed regarding mental health and substance abuse disorders. And so essentially, they dictate that if these benefits are offered, that there cannot be any type of discriminatory practices regarding those particular benefits, as opposed to maybe, general medical benefits. So we'll go over some general rules and FAQs about those. Executive Order 13813, we'll touch on very briefly because it is something that was recent, but it has implications on association health plans. However, I won't spend too much time on that because association health plans really aren't what we're looking at here. Let's see here. So brief introduction to background of ERISA Part 7. So essentially, Part 7 includes several different statutes passed by Congress. Some of the earlier statutes Part 7 contains include Health Insurance Portability and Accountability Act, which is HIPAA, which I'm pretty sure most people have heard of because of the privacy provisions within it, but it also has to do with, a person's ability to have, I guess, health coverage post being terminated or experiencing some qualifying event. It's not mentioned here, but of course, COBRA is probably one of the laws that you will deal with if you run a business and sponsor an employee benefit plan like a health plan. COBRA essentially is simply a law that requires that if a person who works for you, if they are terminated, whether it's voluntary or involuntary, so voluntary being someone quits, involuntary being, you had to let them go because maybe business is slow, revenue is down, whatever case might come up, so long as it was not termination for gross misconduct, which I think we all kind of, inherently know what that means. Gross misconduct being, I don't know, like theft or putting a coworker's life in danger, something really egregious. That's they're going to be entitled to COBRA. Same thing with a person who experiences a reduction in hours. So let's say that maybe you have to cut a person's hours from, I don't know, 40 to 25, something like that. That's also a COBRA qualifying event. And so the important thing for you to really know is just that there are some notices that are required to go out to participants and their beneficiaries. And so that's, just called a general notice or a COBRA election notice. And there are templates available either through our website or also through other human resources websites. Mental Health Parity Act, that goes hand in hand with a more recent law, which is often referred to as MAPIA, Mental Health Parity and Equity Act. That, like I said, is aimed mostly at making sure that when mental health benefits are offered, whether it be for what we normally think as mental health, like visiting a counselor, psychiatry, more from the medical side, or even, for example, substance abuse disorders, it's merely to make sure that there's no type of discrimination going on in terms of covering medical, surgical benefits versus these mental health benefits. WICRA, Women's Health and Cancer Rights Act. Essentially, this is a law that covers women who have undergone mastectomies. And so there are a series of procedures and or, like ancillary care that has to be covered in connection with such a procedure. Pretty self-explanatory. Newborns and Mothers Health Protection Act. This basically stipulates the minimum amount of time that someone can be in in like a facility. So like usually a hospital. It essentially says that the patient cannot be discharged before a certain amount of hours. Of course, the patient, could discharge themselves, but legally speaking, they cannot be discharged forcefully before a certain amount of time passes. I think we could probably all appreciate that one. Continuing some of the laws that we have oversight for, genetic information non-discrimination, that's pretty easy as well. So essentially prevents carriers or private parties from discriminating against people based on genetic information, maybe predisposition to some kind of condition. If you guys recall, before the Affordable Care Act, it was honestly fair game to deny someone health coverage because of pre-existing conditions, right? Because they're probably going to cost the plan more money, et cetera. These laws are meant to deal with that. I mentioned this a moment ago, MAPIA, so I'll skip over that briefly. I guess they wanted to mention there was a law that was passed before that. Michelle's law, just a law that has to do with dependents, because like if you have a child or someone in the plan has a child, it basically says that if they are on some kind of leave from studying at a university or whatever kind of educational institution they're at, it prevents the dropping of their health coverage, because I guess in this case there was an unfortunate problem with a college student whose coverage was dropped, and of course she passed away, and that led to advocacy for this type of legislation. She was not able to obtain health coverage due to the circumstances and the legal framework at the time. CHIPRA, this is basically just to bolster existing children's health insurance programs, otherwise known as CHIP, which are available across the country in different states. Illinois definitely has this. Patient Protection and Affordable Care Act, the ACA, like I mentioned, the Affordable Care Act, which we're probably all very familiar with from the early 2010s. 21st Century Cures Act, I won't go into that too much. Development of regulations, all that's important here to really know is that there's sort of like what's called a tri-department process. So the Department of Labor issues, of course, its own interpretations of these various laws, and we help enforce them mainly through our agency, the Employee Benefits Security Administration, or EBSA for short. Health and Human Services, otherwise known as CMS, the Center for Medicaid and Medicare Services. They also have a role in interpreting and or crafting these various regulations and laws. And the Department of the Treasury, the IRS, like they say, there's only two things certain in life, death and taxes. Of course, the IRS has something to do with these regulations. Arrangements subject to Part 7. Okay. So group health plans, the definition of an employee welfare benefit plan that provides medical care to employees and their dependents directly or through insurance reimbursement or otherwise. So essentially, you're going to have to know that these arrangements are subject to Part 7 and self-insured versus fully insured plans. Most plans are honestly going to be self-insured, meaning that the employer will probably pay out of their general assets, but just know that that distinction that I made last week still bears some relevance. Excuse me for one moment, please. I'm going to see something here. Just a second. I just realized that I may have the wrong PowerPoint. Not the wrong topic, but the the wrong version of what I was going to give you guys. I apologize. Okay, so I'll continue from here, and I am correct. I did have the wrong one. So arrangements not subject to Part 7, just because it's worth mentioning. So very small group health plans, generally speaking, these are going to be plans that have, two people or less, which I guess could happen in your particular circumstance, seeing as we're talking small businesses. But in this case, I think that this is probably something that will apply, but church plans are one thing. So I don't think that applies to anyone here. Governmental plans, definitely not. Accepted benefits, definitely not. Just know that most of you will be subject to Part 7. It's probably the point of the slide. The Affordable Care Act market reforms. So essentially, this law was crafted to address a lot of particular situations, right? So grandfathered health plans, that basically refers to plans that were in place before the implementation of this law. So that will not really apply to anyone here, because theoretically, we're talking to you about starting your own health plan. Prohibition of pre-existing conditions, that's very important. Like I said, this law prevents, denial of coverage based on genetic information or pre-existing conditions, so like claims history. Wellness programs, basically things that are designed to improve the health of the participants so as to probably decrease the amount of claims in the future. There are just some rules regarding, participation and I guess, having reasonable standards for those programs applying to their participants. There's a whole slew of different sections right there, but I think the first ones are probably the most relevant. There are, rules about certain reporting to participants, such as, the plan documents, which they refer to as a summary of benefits, or the summary plan description. That also is within ERISA, which is the law that we talked about last week, the Employee Retirement Income Security Act of 1974. They addressed that as well, but I guess they felt the need to bolster that. So wellness programs, essentially what we have to stress is that there are non-discrimination requirements. So, the rules have to apply generally to everyone within the plan. There has to be like a reasonable way to meet the requirements to benefit from these certain wellness programs. So I guess probably the most common ones are, plans designed or wellness programs around people maybe stopping or quitting smoking, so tobacco use. There could be anything having to do with, for example, healthy lifestyle. So I guess anything having to do with like a gym or sponsoring that type of benefit for participants would be a wellness program. So, like maybe the employer through this plan will reimburse participants for like a gym membership up to a certain amount of dollars. That's a wellness program. Just know that non-discrimination, I guess, would be the point to stress here. Summary of benefits and coverage and uniform glossary. Essentially, these are plan disclosures that are required of employers. They have to include instructions for various processes within the plan. There is a template that exists, and it could either be provided by us, by the U.S. Department of Labor, or which is available on one of our sites actually, or by the insurance carrier that you choose when you set up your plan. They also have these templates. It's important, not really to alter them, although there are things that you may need to cater specifically to your particular participants. The summary of benefits coverage, it's a very condensed version of the actual plan documents. It's limited to 4 double-sided pages, so 8 pages. And then there's of course rules around fonts because it has to be legible. And then there are rules about it being in plain language, which most templates already are. So that's not really a concern for you, I would imagine. Coverage examples. Their required coverage examples include maybe rules about having a baby, managing type 2 diabetes, sorry, ER visits, medical visits, etc. So essentially you have to provide necessary information on, how claims are processed under certain scenarios. And so this is mainly to generate some kind of estimate cost sharing for the consumer. So like the summary of benefits will typically use percentages, right? So like if you use an in-network provider for this type of service, the plan will cover X percentage of it. And then they'll say, well, on the other side, the participant is responsible for X percent. So like, let's just say 80-20, 80 the employer, 20 the employer sponsored plan, sorry, 20% the participant. It'll be laid out like that. When is the SBC provided? Just moving along very generally to plans, it's as soon as practicable. You'll find that language with a lot of laws very vague, but then they'll actually lay out the the hard deadline, which is 7 business days after there's a request for an application for these benefits. To the participants and beneficiaries, so like the employee, their spouse, their children, you have to provide it with written application materials no later than the first date that the participant can enroll. The first day of coverage, it must be provided no later than the first day of coverage. So generally speaking, this is something that's going to go to participants probably as part of like open enrollment. And then, by the time you get to their actual first date of coverage, they will already have this, this documentation for their records. Upon request, also, this has to be provided, just like the summary plan description, the major plan document. It has to be within a week of a person receiving or of the business receiving a request for this document. Special enrollment would be like, I don't know, let's say, for example, that you have an employee and they have coverage through your health plan and their spouse all of a sudden finds themselves unemployed. Well, one of the things under HIPAA, actually, the health insurance portability, is that they have 30 days to request enrollment in your employer sponsored plan that they would be eligible for had they not been working. And so in that case, you have to provide that to them as well within 30 or within 90 days of enrollment, sorry. Internal claims, just very generally, there has to be some kind of claims process or processes. And so there are 2 main types of claims: internal claims and internal claims, internal claims appeals processes, and external review, which is when the person has exhausted their internal appeals. Generally speaking, most plans are probably going to be laid out to have 2 internal appeal possibilities. If for whatever reason it still continues to be denied whatever claim they have, if it has to do with medical necessity, which a lot of claims do, it can go to an external review if the participant chooses to do so. There are time frames for all this. Usually internal claims or internal appeals rather, you have 180 days from the time that you receive a denial for benefits to appeal it. And it usually has to be in writing, though I think a lot of carriers are moving to making that easier for participants by having them do it online or having them do it via the phone. But usually it has to do with writing. Adverse benefit determination, just a fancy way of saying claims denials if you're looking at the slides. Notice of urgent care determinations. This is something that has to be done within 3 days of a person, requesting like an expedited appeal, possibly in the case of an emergency, like maybe someone needs to be admitted to some kind of facility, and so maybe their life is in danger, or their health depends on it. There are expedited processes, which is like an urgent care determination. It has to be made within 72 hours of receipt of that claim. I won't go into too much of the other 2 points. Those are things. This material is really dense, I guess, is the point, and a lot of it applies to very specific situations. The process just has to be fair across the board for the participants that are in the plan. So there are provisions as well with regards to language. So with respect to an address to which the notice is sent, if 10% or more of the population residing within that county is literate only in the same non-English language, which in most cases is probably Spanish. I'm sure there are other languages across the country where that could be the case. But if you find yourself in an instance like that, it's probably best to talk to us, but just know that you're probably going to have to send out some kind of applicable document in that particular language. You can see that data on the CMS website. So if in doubt, visit that. I'll move on from this. Notices, of course, there are notices that must be provided with regards to internal claims and appeals. So like, for example, I don't know, adverse benefit determination notices. So denial notices, that's something that the carrier will probably take care of. The person's rights to appeal, people get EOB, so like explanations of benefits, those are all different types of documents. I won't get bogged down in that. Deemed exhaustion, so like if a person goes through their appeals, like I said, they do usually have an external appeal, and so there are agencies or companies that provide these services to the plans, and to review essentially that the plan denied something correctly. External reviews, exactly what I was mentioning. Independent review organization, that process will probably be carried out by the carrier themselves. They'll go to these independent review organizations and they'll request this service, and then they'll tell the participant if the benefit was correctly denied or not. Mental health parity. This was a law in 1996, though. In 2008, another law, a stronger law, was proposed, which is the Mental Health Parity and Equity Act. And so this is mainly used to address, like I mentioned previously in the presentation, mental health and substance abuse disorders. Essentially, with regards to medical surgical benefits, they have to be at the same level as mental health and substance use disorder if those benefits are offered. There's an anti-abuse provision, so that might be something worth looking at if you find yourself in a situation where there's questions as to whether a mental health claim should be covered or not. It does not apply to employers with 50 or fewer employees, but non-grandfathered small group health plans must include medical coverage for mental health and substance abuse disorder benefits. Let's see here. Financial requirements. So you'll hear a lot of talk about these quantitative treatment limitations. So this basically mainly has to do with how to avoid, I guess, some kind of issue with mental health parity. So let's just say maybe benefits are covered for medical and surgical at, I don't know, 60% in network or 80% in network. Well, the plan can, for example, say, oh, mental health claims, like let's say for visiting a counselor, I don't know, maybe you only cover 60% instead of the 80 that's covered for the medical benefits. That would probably be a violation. If you, for example, charge a co-payment, or you have a co-payment for visiting a normal doctor of $25 or $30, but you charge $50 for a mental health professional, that's also a blatant violation. So I mean, this seems really dense, but a lot of it is pretty straightforward and common sense. Classification, that's too dense for us. So yeah, there are these 6 classifications with regards to these benefits. So there's inpatient in network, inpatient out of network, The ones that are mentioned there basically is the person in a facility or not, I guess would be the distinction, and whether they're in network or out of network, emergency care, prescription drugs, etc. Let's go through this all a bit dense. Non-quantitative treatment limitations, important to mention as well. As we move forward, non-quantitative treatment limitations. This might be, for example, making it harder to get mental health benefits, not by, I guess, monetary incentives. So like, if a person had to pay more for mental health benefits than their normal medical benefits, that could obviously dissuade them, but that's quantitative. Qualitative would be, for example, requiring pre-authorization for mental health benefits, but not medical surgical benefits. Clear and blatant violation. I'd say that's probably the most common. Disclosure requirements, mental health parity will be addressed in the plan documents. This is probably not something that you would have to worry too much about, as you're probably not going to be the one who's directly sending out these determination letters. Is probably the carrier, but just know that there are certain disclosure requirements with regards to mental health parity. There is a MOPIO self-compliance tool, which I can provide a link for at the end of the presentation. It came out in 2018, and so it'll basically have like a checklist of how to make sure that the plan is in compliance with mental health parity provisions, both for quantitative and qualitative treatment limitations. Okay, so Executive Order 13813, that was actually introduced in 2017, and so it directs departments to consider proposing regulations or revising guidance with regards to association health plans. Not really something that applies here. Short-term limited duration insurance plans. So this is basically like to cover gaps in insurance and or the availability of HRAs, health reimbursement arrangements. I won't spend too much time on this either. Health reimbursement arrangements are basically like a way for the employer to, as it says, reimburse their participants for certain expenses. A lot of times it's for specific kinds of medicines, for specific types of services. I don't know, like maybe perhaps blood tests, things like that. There are some rules regarding this as well, but generally speaking, it is something that is pretty straightforward. If you go on CMS's website as well, if I'm not mistaken, they have a list of what people can actually use money within these HRA accounts for. So that's something that shouldn't be a cause for too much concern. It's a lot of information in these presentations. I wish I could create my own PowerPoint catered to you guys specifically, but I have to work within these constraints. Transparency, like we talked last time, it's very important for the participants to know that that the plan or that the people operating the plan administrators are doing things fairly. Compliance tools and resources. I wanted to take a moment outside of the presentation to go over some particular employee benefits laws that maybe aren't under the purview of our agency, but they are under the state of Illinois. So if you go on the Illinois Department of Labor's website, they actually have a very useful list for all our small business owners of the different, I guess, disclosures that have to be made available for participants. So if we scroll through here really quick, you'll see things like the Victims Economic Security Act. We'll see things about employee classifications, occupational safety. You guys see the titles here, and it tells you, for who this is required. And I'm going to guess that it probably applies to most of you. There are some federal laws that, I guess I could speak to with more eloquence. Pregnancy. So like pregnancy leave. And a lot of this is also available in Spanish, and you could request posters like you see here. There's links for these particular posters, and it tells you what particular agency has jurisdiction over this, where you could reach them if you have questions, including toll-free numbers. I think down here they have federal required posters, which a lot of these laws people will be even more familiar with. So Wage and Hour Division obviously monitors compliance with wage laws. So like anything having to do with employee compensation or payment. So like minimum wage laws, medical leave, people who have federal contracts, if that applies to you, and if you're like a federal contractor, I imagine there are OSHA postings that might also apply here. Yes, it is, Occupational Safety and Health Act. While I don't endorse, because it would be wrong for me to endorse a particular business, there are businesses that you'll find online, or services that you'll find online, where they sell these posters, if you will. And so like, I think they also provide the service of, if there's changes in these laws, which is probably not something that happens very often, you could go on these websites and, for example, I guess this is almost like a warranty. So like if something changes, they'll provide these posters, or a replacement set of posters, for you, and they're available in English and in Spanish. So like this particular website, Labor Law Compliance Center, they sell this gigantic poster with all the posters contained within it. I don't know, that's just something worth looking into. But like I said, you can usually request these posters individually from these particular agencies. With that, I think we could pretty much leave it at that. Like I said, a lot of these laws are very specific and dense, and going forward, if you guys maybe think that you would benefit from a presentation about COBRA benefits, or MAPIA, mental health parity, the Affordable Care Act, anything like that, or No Surprises Act, which is actually something very new. I didn't really mention it in this presentation, but that is a law that went in, was implemented at the beginning of this year. Definitely feel free, to communicate that request either to myself or to Heather there at the Small Business Development Council. With that, I can take questions if you'd like, or if anyone has any question about anything in particular within the presentation that I gave.
Andres, I have a question going back to,
Yeah.
and with the attendees here, there are probably different things that they want to get out of this presentation, whether it's, they're still an employee, they're transitioning to be a small business owner, they're already a small business owner.
Sure.
I think a lot of, and we've talked about this, some of the struggles are, navigating what is required, what's the basic requirements for them outside of providing health coverage, which would be ideal for small businesses. Are there posters, or is there free information from the state of Illinois that people can get? I know that you mentioned there are companies that provide the big poster, or the smaller individual versions. Is there a way that they can get this information for free?
Yeah, so the information can be obtained for free from these, from the state of Illinois in the particular, well, actually even federal agencies, like I said. So there's two sides of this really. So from the state side, they can request these posters via this particular page. You know what, I might as well drop it in the chat box.
Yeah, that would be great.
Yeah, just a moment. Let's see here. So, all right, required, we'll say required posters, state and federal.
And second part of this question is, how does one keep up with the posters? Make sure that that the information is fresh. Is there an email?
Like a subscription, perhaps?
Yeah.
Yeah, there are. So with regards to the state, I can't speak, with as much education, I guess, or with as much knowledge as federal programs. So I'll say this to start off with. The U.S. Department of Labor does have a way to subscribe to their webpage, and they will send emails about any developments in terms of the laws changing, which you'll definitely hear about. Or even, for example, they publish guidance, or maybe perhaps a certain situation arises that they feel may happen with other plans. They'll publish that and they'll make you aware of it. Field assistance bulletins, I think is what they're called. They're usually set up like FAQs. They'll send those out as well. On this website, one second, there is, I believe, a link to to the U.S. Department of Labor's subscription service. So let's just actually look for it. So United States Department of Labor. They may
So
use different terminology. Go ahead. I'm sorry.
it
There we
is
go.
what you're sending, does that apply to state and federal or just state in terms of? going back to
Usually
poster?
they talk about, so like a lot of times when there's a change in the law or something that's worth noting, oftentimes the U.S. Department of Labor will give their opinion on it, or will say that, that this change was made. So in terms of existing federal law, at the very least, I'll include this. Hang on, let's see. Perhaps the Illinois Department of Labor also has this service. I will check in one moment. So for federal laws, subscription, here is the link for that. And then let's see, for the Illinois Department of Labor, they should have it. I would be surprised if they didn't.
Do you find that state laws are pretty much in line with the federal laws?
Generally, yes,
For the most part.
because there are existing federal laws, a lot of states, honestly, what they do is they just default to existing federal law. One of the states that does that a lot is Wisconsin, for example, our neighbor to the north. Illinois does, though, have a lot of laws that are meant to maybe catch blind spots of existing federal laws. So as an example, COBRA is a federal law. Illinois has their own version of COBRA, which they call state continuation, which is usually what small businesses have to comply with. So like, a business that might have less than 20 employees, which is going to be the case for most people here, I would assume. They have different requirements in terms of how fast they have to get documentation to people after they've been terminated, how long coverage has to last, etc. So there are instances where the Illinois Department of Labor might, have something that they pass that is maybe a little bit different from federal law, or maybe it's just meant to bolster that. But generally speaking, they do comply with federal law at a minimum. I'm trying to check here to see if the state of Illinois has anything. I don't see anything that's analogous to the Department of Labor's service. That's something that I'll write down as a note to get that information to you guys, because obviously I'm not going to have you here for like 10-15 minutes while I look for it, but once I find it, I will send it to you. If the Illinois Department of Labor has such a service, I guess in absence of that, or while I look for that, if you do go to that website is updated very frequently. So you could just maybe Google, I don't know, Illinois Department of Labor required posters, and that'll come up, and that'll have the most up-to-date information. But, since we got that question, I'll definitely look to see if there is a subscription service to where you don't have to actively go out and look for it. It'll just come to you.
Okay.
Okay.
Does anyone have any questions, additional questions? And again, you provided great information in the chat. Is there a way that if there are any questions later on that people can get a hold of you?
So I will give you guys my phone number and my email. So my phone number is 312-353-4061, which will pop up in the chat now. And my email is just my last name, Mendez, MENDEZ, my first name, ANDRES, at DOL as in Department of Labor.gov. So there is contact information for our agency, which I could also put in the chat. But if you want to talk to me, since you guys are familiar with me now, that is my contact info there in the chat box. And of course, I'm sure if you ask Heather for it, she'll have it, and she, would be more than glad to provide that to you. Like I said, going forward, we could talk about topics more specifically. So like COBRA, I know that a lot of people have questions about that, especially last year when there was that, that mandate where businesses had to cover the cost of COBRA for a little while. So, definitely feel free to communicate that to Heather, and we'll reconvene and, talk about the possibility of those types of presentations.
Okay, any other questions? All right, just as a reminder, we have our next webinar is same time next week. Do you know your market? It covers a lot of marketing issues that you have, including how to conduct a market analysis. Go to rockfordsbdc.org to sign up, or follow our pages. That would be awesome. Facebook, LinkedIn, Twitter and Instagram, Rockford SBDC. And if there are no other questions, have a great weekend, everyone.
Thank you.
Thank
Thank you,
you.
Heather, again for.
Thank you,
inviting us.
Andres.
Yep, no problem. Have a good day.
You too.